Hi and welcome to Mark My Words. I've got David Kemp here, the illustrious planning consultant who I've interviewed previously on this podcast, this show. He's got many decades of experience in planning. He's worked within councils, so he's sort of sat on the other side of the fence, especially in a sort of legal perspective rather than being an officer. He's been the sort of barrister that they've used when it started to get a little bit smelly for them. So he really knows the law. He's got a lot of sort of granular knowledge in this area. So David, welcome to the podcast.
Thanks, Mark. Good to be here. Thank you. Lots
of our listeners like to know about permitted development rights. They allow you to convert buildings without obtaining planning permission. They really got going under George Osborne and David Cameron. The Conservatives started to accelerate the introduction of new permitted development rights. Offices were the big one. You didn't need planning permission, and you still don't, to convert most offices in most areas into residential. So, David, tell us, is permitted development still relevant? And what are the new sort of permitted development rights that are being or have been introduced recently?
Yeah, definitely still relevant, Mark. I think that when you're looking at permitted development and prior approval and what's happening generally at the moment, there's sort of two things that are happening. There are some of the permitted developments and prior approvals that were already out there. They have been saved. So, for instance, with house extensions, you've been able to extend at ground floor on some houses. So, for instance, if it's a terraced house or if it's a semi-detached house, you can go up to 3 metres at the back, but then you can do a super long extension ground floor to double that to 6 metres instead, and for detached houses to 8 metres instead of just 4 metres. So that was a temporary right. It was due to end in May 2019. That's now been extended. That's now permanent.
And there's a consultation process. You have to put a form into the council and the neighbours get consulted?
That's right. And that's a very good point to raise because a lot of people don't realise that. It's a two-stage process. You have to apply for prior approval to the council first, who will consult with just the immediate neighbours, so just the neighbours who share a boundary with that particular property. It shouldn't be anyone any further away from that. If there are no objections, then you have to put in an application for a certificate of lawfulness for all the other dimensions. So they're basically just consulting on the depth of the extension, and then...
But critically not other matters.
Critically not other matters.
Because if it was a planning application, it would be out to all sorts of consultees. They'd all be getting their oar in.
Absolutely.
And it would become a lot more complicated. So although it sounds like all the neighbours are getting consulted and you put an application, it's not as bad.
No, they're asking the neighbours what do they think about the depth of the extension.
Yeah. And the neighbours will typically come back with a load of irrelevant nonsense often, which is ignored.
Well, they're given 42 days to do so. And if there's no objection, then the officers come back, they stamp it, no objection, then you go on to the next stage as well. Now, sometimes neighbours do come back, typically if they've not been forewarned or you've not consulted with them, and sometimes they come back even if you have had a cup of tea with them or something like that.
If I'm honest, a lot of people would say this is not, the right way to go about things, and also, maybe it's a sort of, against common sense, but I prefer not to talk to neighbours before I put a planning application in now, because I find, especially if it's a commercial sort of area and the neighbours are businesses, at least 50% of the time, no one knows it's even gone in, even though letters go out and all the rest of it, because it might be rental properties or whatever. If it's a residential area, they probably do see it, but less people see it. And I just find that it makes life a lot simpler. If it goes in and then you start the negotiations with the people who see it and aren't happy, maybe then go around and see them.
That's a very good point. And there are applications where I've advocated that approach to clients as well. We've done that recently on an application where we got prior approval, office to resi scheme. We had to go up into the roof and make certain changes to the roof. We didn't consult with the neighbours before making that application. And actually, some of the neighbours didn't find out until after the consultation period in any event.
Mouth shut until 6 weeks after the planning consent or the prior approval comes back.
Yes.
So there's no opportunity for judicial review. And that's it. It's too late.
There are different ways of approaching this, though. And I think on much larger applications, you have to be sensible. You may have to, certainly after the pre-app, think about whether or not you're going to go through a public relations exercise, what your strategy will be.
I've always got a way of not doing that. But
I think
sometimes you have to.
Sometimes you have to, and sometimes there are reasons why. Now, I'm aware that we're going to come on later on to talk about PR and engaging with neighbours as well. But in terms of PD and prior approval, certainly with regards to what's out there at the moment, then domestic extensions at ground level, they've been made permanent. We had a permitted development or prior approval right for shops up to 150 square metres.
And
so that they're Class A1 shops.
Into C3.
Into C3, self-contained residential.
2 units.
No, that's so you can do as many units as you like up to 150 square metres. It's above the shop.
It's not on the ground floor.
Which is not on the ground floor. As long as the area above the shop is some sort of storage or it's an office use, which was part of the shop use, so it was ancillary to the shop, it's not a separate office, for instance, then you can convert that under a separate PD right up to 2 flats in that area above the shop. Okay. Now, you can't just simply send try to subdivide the shop into 2 shops and then perhaps get 4 flats out of it at the top,
because that would require planning consent.
You need
to subdivide it
to subdivide it, exactly, or to subdivide the shop into 2 units before you can subdivide it into flats.
Subdivide it into 2 shops.
So you're limited up to 2 units above ground floor. There's no limit on the number of units at ground floor, but it's a limit on the amount that you can convert in terms of floor space, 150 square metres.
150 square metres and into 2 flats above ground floor level.
Now, so that doesn't apply if you're in a conservation area. You'll have to apply for planning permission. Because the law also allows certain external changes to be made to shops in order to make them into flats. So in the conservation area, that'll usually be a lot more sensitive. And also in what the law calls key shopping areas. Now, that's not really defined in the law. It's a bit fuzzy. So in practice, fuzzy? I tend to look at the local plan policy map. If it's an area where on the policy map, it's designated as a district area, a primary shopping area, second, it carries a specific policy designation, then the likelihood is it's going to get caught by that provision. And so, erring on the side of caution, you probably won't have PD for that. Now, that same right for shops has now been carried over to hot food takeaways, which is Class A5. So you have the same PD rights for A5 as you have for shops. And I think the government and councils, for various reasons, they're quite happy to see hot food takeaways go over to shops for all their environmental reasons and also philosophical reasons to do with obesity in the country and all that sort of stuff
and smelly sort of, it causes complaints. Hot food takeaways cause smells. And flats above them are hard to finance for a reason.
Indeed.
So you can't go from a hot food takeaway into a flat.
No.
But you can into A1, into retail.
Well, no, you can go from hot food takeaway into flats at ground floor level.
Oh, can you?
Up to 150 square metres.
That's good.
Okay. And then if it's above the hot food takeaway, then that area won't have the same PD rights as you had for an area above a shop. But the fact is that because you're losing that use at the ground floor, which anchors the use of the area above it, the likelihood is you're going to be able to split it in any event. Absolutely.
Going to let you have planning consent.
Planning consent
for
under a separate
the first
application.
Floor.
So those are the main things. There are some new areas that are opening up as well. So where you have shops, for instance, and you perhaps might not have the ability to change over to residential, you can still now change possibly over to offices. Now, this might be quite useful in certain circumstances.
Shops to offices.
Shops to offices up to 500 square metres, so not up to 150 square metres.
That's annoying, but I mean, that's good for the likes of me. When I'm buying retail, converting to residential, I need planning consent because they're good size. But if I get really buggered and I don't know, there's a change in administration in the local council and they suddenly decide that it's not happening, we're not converting shops anymore, then I can convert it into an office up to 500 square metres. But the retail has to be up to 500 square metres as well. Is that right?
The retail, in terms of
the existing space.
So you can convert, let's say, for instance, you have
10,000.
a 10,000 square foot retail unit.
Which I've got at the moment. It's about 13, 12.
So only the first 500 square metres you could really convert to offices. Which is, it's not ideal. The thing is that...
but there's retail on the ground floor.
You've got retail on the ground floor.
So you could sort of... It'd get you out of a hole. Get me out of a hole anyway.
Absolutely.
I'd turn it into a serviced office with desks. There's a lot of that springing up around the country now. It's bringing offices back into use. And it's almost like making an office into a HMO building.
Absolutely. And it's politically often a lot easier to change to offices at the moment than it is to change to shops. I think also, to change to residential. And also, in some areas, because there has been a decline in office supply, then office yields are actually on the rise in some areas.
It's quite,
at least it says it covers your arse. It helps to mitigate your loss rather than having an empty unit where you're going to have to be paying business rates. And you've got other outgoings and possibly maintenance to keep that going. Perhaps if you're doing a land assembly as well, then. In trying to put a number of units together, at least it keeps some money coming over, which is particularly useful if you're having to play the planning game with the council in the meantime. Because otherwise, they might try and push you around in the planning system, hoping that you're going to be desperate. You're going to need to generate some cash flow and some money, but this helps to keep the walls from the door, helps to keep you in the game for longer, and to take... and gives you more confidence to take a more robust position in your negotiations with the council.
I've certainly noticed that more recently. When you talk to officers and councillors here in Peterborough, they've got the idea that there's a lot of poor office conversions with no windows, and the tide has sort of turned around here. Obviously, it's still going on, but there aren't many offices left in any event. But about 500,000 square foot of offices went from the town centre into residential. Great for the people that did it. But the situation now is there's not really that much free office space left. I think the rents have, they're going up. There isn't much being built because still there's a massive gulf between what an office building like this is worth, which is sort of 15 years old, and a new office building. This might be worth £135 a foot. To build new, you're going to have to give land and all the professionals and the legals probably 200 or over a foot. So there's a massive gulf between new and existing. It's huge. So of course people start building. So the existing ones, the value is very firm. So they're not attractive to convert, and the political sort of, the political winds are turning against it. Perhaps not turning against retail converting, though, because there's still a lot of empty shops and they're not fit for purpose.
Yes, I mean, you've got some big names like House of Fraser in Oxford Street, prime in London, which fell into trouble. And when you're looking at news like that, you're looking at that sort of situation, it just brings it home how much traditional retail is struggling in this country.
Yeah, it is.
So you've got those. Quite an exciting possible PD, prior approval, that may be on the horizon. We're probably expecting to be either coming into law either later this year or hopefully by the spring of next year, is air rights. So this is the development of land above existing shops, above existing offices and existing buildings.
I've been involved in this quite a bit recently, having to get planning consent, but effectively buying a building that's sort of not very high, with two buildings either side that are much higher, and that air is obviously developable.
Yeah. So the government have consulted on this. They've indicated where they may be looking to draw the limits in terms of this. So you're looking at buildings where they would be up to perhaps, they would allow air rights up to 5 stories gross.
Yeah.
So if you're at 2 stories already, you can have another 3 stories on that. If you're at 4 stories already, you can have another 1 story on that. In terms of the conditions and the restrictions and limitations that will be placed on that, I would imagine there would be a lot of stuff around design and its general appearance at the front has to match what's existing. There's a lot of uncertainties about how we'll have to deal with things like sunlight and daylight and outlook with buildings which have neighbouring windows.
That went on to that. For me, not so much the neighbouring windows, but just very deep floor plate.
Yes.
Not being able to get light into the central units probably went on with 6, 8, 9 months. Negotiating about that. Because there are no standards.
Yeah, absolutely. And we don't know necessarily how the law will draw conditions and restrictions on how it will deal with those issues with the new floor space, as well as how we have to bring in an assessment of those standards or those issues on light
for the neighbours.
Now, there are 2 aspects on light that probably ought to draw to your listeners' attention. There's an aspect which is to do with planning and one which is more to do with legal and property law. Now, the planning is sunlight and daylight standards, and that's measured by what we call the BRE, sunlight and daylight, building research establishment.
We brought that out in the end because the planning officers, there was no sort of slide rule. And it was, we don't think much light will go in there because it's north facing. So we brought those BRE standards in, and I think in the end they accepted them because it's the most objective thing that you can use. So when you look at that, if you're a developer, you need to be smart. You need to look at the other one as well, what we call rights of light. Now, that only applies, really, if a building has acquired a right, either usually by contract, but usually by prescription over 20 years, being there for at least 20 years. So you'll need specialist legal advice, property law advice on this. It's not really a planning matter. If you get planning permission, and the planners have looked at it in terms of sunlight and daylight, and they've said it's okay, that doesn't mean that you've got rights of light permission. You will need to get that either by law or by the neighbour, because if you don't, then at the very least they have a right to claim damages for any loss to them, and that will have to be specifically assessed. There are a particular formula for that. At worst, they could take out an injunction in court to stop you from developing. So it's really important you're on top of that issue. And this is obviously it's interesting because they're trying to, I don't know who it is, department, communities and local government, they're trying to define these permitted development rights and what controls you being able to build up without planning consent. And clearly, the amount of light going into the new developments windows is important. But what we're talking about here is neighbours' windows and you reducing the amount of light going into those. Surely, there's an argument to say, well, the planning system doesn't need to worry about that too much. You could argue that's the way that it, light touch, let that deal with it. That can sort of deal with it, rather than the planning system.
And it's an very interesting aside. Just to finish off a couple of points on PDs, prior approvals, etc. Office to Resi, still an interesting play. I think in some areas of the country there may still be enough profit in the PD and prior approval scheme alone on that, but by and large, what we're finding is that site values and the land values are going up. It's going to become more expensive to buy them because people are a lot more aware of the opportunity. The vendors are more happened. So that will erode your profit margins. And also, as experienced people such as ourselves who are experienced in how the investment market works, how it works with the banks and with your investors, people throw stones at the valuation in terms of what the possible exit will be on a scheme like that. We don't know what's going to happen with Brexit. There are warnings from the Bank of England about what's going to happen with the economy.
Labour want to remove permitted development rights on offices.
All this sort of stuff. So it's prudent when doing these exercises to see if it still works at 5 or 10% lower than the existing GDV.
I think that's a good idea.
And also, we don't know what's going to happen with the labour market, and labour costs could rise, and build costs could rise.
Well, they
by
have
5%.
been. They have been.
So they have.
I've really noticed in the last sort of 3 years, construction costs have gone up a lot.
So what we're seeing is that PD and prior approval and office to resi may still be there. It still gives you a good foundation. Perhaps 5, 10, 15% profit on cost. With experienced high net worth or very high net worth investors, that's not going to be enough to entice them to take the risk on some of these schemes. They're looking for really about 35 to 40% profit on cost.
Yeah, because if
you need a planning play.
You do.
On top of
That's
that.
exactly it. Because if you're in there and you're getting 10, 15, I don't know, maybe 20% is all right for some. Often when the issues come out, then that's down to 5.
Absolutely.
And I see that all the time. The projects I do, they're more like that. They've always got a 3 in front of them, percent, you know, on cost usually. So 30% plus on cost usually.
Before finance?
No, after everything. After legals, finance, professionals, the whole lot. The key to this, I think, you've just touched on it. It's adding the value by building on top. Maybe you can put an extension back or sides. And maybe you can extract something out of the car parking as well. If you can do that, I think that is usually what is the difference between them working and not working. So you're normally doing a bit of PD, but then you're getting stuck in with the planning. Another thing, and it's not, well, it is planning. Recently, in Peterborough, they've got very interested in noise. And the environmental health officer is now a consultee. Didn't used to be on these schemes, but is now. And she often just says, right, I want mechanical ventilation throughout the building. But in order to demand that, she gets you to do a noise report. And the guy that does the noise report puts all these microphones around the building. And he listens to noise. Now, if you're in the middle of the town centre, there are nightclubs. And there are a couple of nightclubs around sites that I'm doing. And she insisted on us recording these nightclubs when some big bands were playing, when the doors were open, and insisted, well, that's how they operate, so you know the doors need to be left open. And I consulted a legal specialist last week, and what I realised was they are contravening their licensing conditions. The licensing conditions of that nightclub are those doors should be shut. Therefore, she can't consider a noise report which is based on doors that are open. Which I'd not even thought about. The other thing, which somebody else brought to my attention recently, and I'm just checking into this, does the nightclub even have planning consent? And are they breaching any planning conditions in operating the nightclub? Because if they are,
that's a good point.
Then that's something else you can use. So you've got to pull these little things out.
And as we're on the subject of angles and wheezes and things like that, coming back to the shimmies, a few stepovers, lollipops as Ron Atkinson used to call them. But the thing is, what we're talking about here is coming back to the issue of air rights. Now, I want to bring in the issue of affordable housing on this, because in some cases, there would be the opportunity to build on top of your existing building And obviously, the size of the units you're going for, they're going to be limited by what you can do under, usually on a local plan policy, or if local plan policy brings it in, the national described space standards.
The minimum size.
The minimum sizes.
Yeah, so we haven't got any around here, but on a scheme I did recently, the officer just said 40 square metres. Yeah, that's my minimum.
So generally speaking, if you are working with a building where you might have to then take the roof off and you're building new units on top, there is a danger that the council might begin to see that if it's the same developer, and it's, albeit there's a break in the scheme, but it's the same developer, they might see it as a continuation.
I've always wondered this on the 106 or the affordable.
Yes, so they might.
I've wondered this because I've got a site now where I'm just applying for some extras, and they're going for it, and they're not even talking about 106. And I've often thought to myself, why am I not just breaking all this up?
So if they do,
same
my
developer.
Advice is, my advice,
the application from someone else.
Well, my advice is my advice is perhaps set up a JV with somebody else, or however you want to work it.
Anyone can make the planning application.
Anybody can make the planning application.
But
the thing is, the air rights could be in a separate title.
Of course.
Set up a separate, because obviously, if they start looking at the title and they see it's still Mark Homer behind it, Mark Homer or Progressive or whoever,
I've never had it here where they do.
It's belt and braces. I'm just saying, you never know.
I'm sure, and I bet around London they're
in
more
London
on all
they
this.
are very, very cute on all this. They start doing all sorts of. They start going into
digging away.
They go into court cases and stuff like that.
Do they?
Oh my God! They go to the ends of the earth to try and find a way to get the developer to pay, because it's an awful lot of money for them. So what I'm saying is that sometimes it's worth having an arrangement with somebody else you can work with. You put the title in a SPV, and it's then therefore not necessarily clear that that SPV has anything to do with the freehold owner of the flats and the building below. So to all intents and purposes, it is a new developer. It's a new title. It's a separate project.
She has a different surname to me.
Absolutely, it could be anybody. So you could split off title in that way, and therefore help to insulate what happens above the existing building from dragging you into affordable housing.
I've always wondered where the line is with this. Where they can...
No one knows where the line is.
Oh, don't they? Well, this is what's great about planning, isn't it?
It's grey, isn't it? So much of planning is grey area. And it's all about where we see if we can push the boundaries. Half of my week is involved in having to deal with questions which had never been asked before.
And finding the shimmy.
And see if we can test new things and how far we can push the boundaries as well.
Yeah. That's really interesting, because around here, if you're below 14 units, you don't have any affordable housing, but you do have SIL. Above 14, you've got affordable. So a lot of the time, you want to keep it below 14 and probably just give them the SIL payment. If you can't, persuade them to sort of drop the affordable. So it's interesting. Very interesting.
And lastly, certificates of lawfulness on existing uses. Obviously, if you buy a building, sorry, excuse me, you see it's been used as self-contained flats for at least 4 years. There's no planning permission on there. There's no certificate of lawfulness. Then let's say you're looking at buying that building, but you're entering into negotiations with the landowner about it. The landowner doesn't have a record of planning to it. So you'll go along, you'll say, well, it's a great opportunity, but you'll start sucking through your teeth and you'll start making those noises.
It's going to be trouble.
It's going to be trouble. It's going to be a lot of risk.
Who else is going to buy this?
And if we don't buy it, I mean...
And the council find out.
Well, they're not going to find out from us, Mark. But if they did, and curtain twitches and neighbours, these things can happen. So, again, they're not going to find out from us. But if they did, then it'll fall on you because you're the owner. And you'll lose all this rent as well. And you'll have to change all the layout because some of these the sizes of some of these flats are way below the standards, the minimum standard.
Proceeds of Crime Act, last 4 years worth of rent.
So we have to take that risk on. We're happy to take that risk on for you, you know, as part of the deal.
Subject to.
But it's going to have to be reflected in the price, obviously. So you can see how it evolves. Yeah. As part of that, you want to make sure that you're getting a statement from them. Yeah. Particularly as, you know, as the new owner, you won't personally have had the 4 years experience of being the landowner collecting the rents. Yeah. So you want to get that information from them in writing, because once they've got the money, the deal is completed, they're off to sunny Barbados or whatever it is. They don't really care. They don't want to. They can't be bothered to cooperate and so on and so forth.
So you want to get in any invoices from when the works were done.
Exactly.
Maybe an affidavit from them saying when it was done.
Exactly.
Tenancy agreement showing the continuous use.
It's exactly the same if you're dealing with anything where you need some sort of evidence where there's, let's say, for instance, there's been no market interest in an existing commercial use, pubs, offices where you don't have PD, and you need to prove that there's been no market for it in the last 12 months. Yeah. The moment that deal is done with the freeholder or the existing publican, they're off the scene. You won't be able to get hold of them for love or money. So you want to get that information from them before they go.
Yeah, absolutely. And it's a condition of sale.
Indeed.
Or, you know, condition of exchange or whatever.
Absolutely.
Yeah, and then the reality is, I mean, I had one of those recently. I was a little bit cheeky. It was a HMO. I'd put a couple of extra rooms in, but I'd made them self-contained. What happened was, we converted it. We converted it into an 8-bed, but two of them had not just an ensuite; they had a kitchenette as well. Yeah. I just thought I'll test this one, see how this rolls. So we ran it for 5.5 years. Really, really good. Good rent, everything else. Good size rooms, good standard. I took it back to brick. I put all en suites in, made it very, very nice. Yeah. Of course, October 2018, which is what I didn't see coming, they changed the law, which basically said that, because I used to do a lot of 2-story HMOs, they weren't licensable. Sure. Right. But as soon as October 18 came along, any HMO with 5 or more people in became licensable. So we had to get a license. Right. So licensing officer comes around and goes, oh, this is great, whatever, measures all the rooms, everything. He's got a few things he needs doing with a couple of extra smoke detectors, things like that, but nothing particularly major. Yeah. Goes away, decides it's got too many people in it, so reports me to planning enforcement. So planning enforcement are on the scene, and they have a look and whatever. So I get one of their officers, and I'm like, can you send everything in to me? So I got my local planning consultant on the go. What are we going to do? So he had a look and he said, well, I think you'd get planning consent anyway because there's enough parking on the street, all this other stuff. But let's just have a look at what you've got. So I said, well, the thing is, we did this 5.5 years ago. But because I did have a sort of exploratory conversation with the planning enforcement officer without giving anything away. Yeah. She said to me, well, it's sui generis in any event because it's an 8-bed. And you've gone and put two of them, you've put kitchenettes and en suites into their studio flats. So I said, oh, God, right, whatever. So as far as I'm concerned, this is not, you're not converting into C3, it's into sui generis, so it's 10 years. Rather than 4 years before it becomes established use and immune to enforcement action. So I had a little think. I just went away and I thought about this. I thought, eventually, I it took me a couple of days, but I thought this sort of little brainwave came over me. I thought to myself, surely, if 2 of the flats are studio flats, as she puts it, they're C3. In any event.
And you only have to prove 4 years for those.
And you only have to prove for 4 years, and I've got 5.5 years worth of evidence.
So that brings the rest of them within, there's 6 units. So
there's 6, and that's permitted development into C4 in any event. Yeah. So I rang her up, told her, she went, oh, I'm not having this, whatever. I said, but Julie, you said to me, it's, whatever. Yes. And anyway, we got all the evidence. She said, I want the invoices, there was a conservatory I put on the back as well. But that's building works, so that's 4 years. I got all the evidence from that, whatever. sent it all in. She just came back and said, I think it's immune to enforcement action. So it's worth learning all this stuff. There's a lot of value in it.
I mean, the lawful use angle is also particularly interesting from the point of officers to resi and a lot of the PD rights as well. So, for instance, where it's coming up, and I'm finding it coming up more recently, is on the exit to a deal.
Yeah.
So, with planning permission, PD or prior approval, it's all usually prospective, unless, of course, you've done the works already, you've done a change of use, and you're going retrospectively. But with prior approval, it's always prospective because you're working from a position of converting existing offices. Okay,
and if you go ahead,
you can't go retrospectively.
You go ahead and convert it without the prior approval. You then need planning permission.
You need because you've lost the use.
Yeah.
So let's say you've got an office development. You get prior approval. That's an abbreviated. It is only in effect an abbreviated form of planning permission. So what you'll often find on exit is the funding lawyers will turn to you and say, well, we're happy to release the funds, but we need proof that what you've built matches the prior approval in the end. So it's an established lawful use. Now that seems a little bit of overkill, but it's often guided by the funding lawyers. And I've had it a couple of times. And so sometimes they will accept a letter from the planning consultant. I sometimes have to do these letters, or they will accept it from a barrister. But more often than not, and the only conclusive way in law of proving this is a certificate of lawfulness for existing development.
So this is
you have to apply to the council. It takes another 8 weeks.
So this is to say that you built what the prior approval was for.
Yes, or a planning permission, what it was for, exactly.
Oh, and a planning
yes, because the planning permission says you have permission to build this. You get to the end of the period of build, then the funding lawyer says, yes, well, turning the clock back, turning back the other way, did you build what you had permission to build? So we want to make sure that there's not going to be any non-compliances and that you actually executed what you were given permission to build in the first place.
So how do you ascertain that? Just a letter from a planning consultant that says he's had a look round?
Well, they might settle for a letter from the planning consultant or opinion from a barrister, but they might also ask for a certificate of lawfulness from the council.
I've never had that. Ooh,
yeah. Now, it has come up a couple of times. It's also a little bit of an issue at the moment because with prior approval, let's say officers to residential, if the council don't give you an answer in 56 days, then you get deemed prior approval, you get deemed consent.
Gee, I didn't know that.
So,
they've asked for an extension.
And I recently got that on a development for about 30 flats in Great Yarmouth. And the council actually sent us an objection from the Environment Agency on flooding. And they were about to refuse it. The 56 days works from the date of registration, or rather the date on which they receive all the... Well, no, not validation.
They're not allowed. Are they allowed to validate it?
They can validate. No, they can validate it, but the 56 days works from the date on which they received a valid application. Okay?
Rather than with a planning application, they say it's valid from this date. So it's not that date.
They might have validated it maybe 2 or 3 days or a week afterwards. But it'll be the date.
Well, I've had them 3-4 weeks.
So they were 3 days out on our application.
Superb.
So
you're like, well, in any event, we've got it.
Well, yes, I did. Now they put up a fight.
Did they? Yeah.
And they said they came up with all sorts of reasons as to why. They now queried whether or not we had deemed prior approval.
Yeah.
Now that was a problem for my client because
their
lawyers kept on looking at the planning record, saying this still looks as it's saying undecided.
Yeah.
And for a long time, the council have been holding back and refusing to change that status on the planning record. Now, we've recently, in the last few days, got them to agree to change it. We had to go through a bit of a process with them and tacitly threatened judicial review against them and all that sort of stuff. But they have now agreed, very kindly, to play ball, and they're now going to change the record. But I raise it because as developers, we're not in planning. We're not going through the planning process as an academic exercise. This is to generate value.
Yeah.
So, it's all very
what's
well.
The practical implication?
What's the practical
if you can't do it anyway,
exactly.
then it's a waste of time.
Exactly, and it can cost a lot of money. When it comes to selling flats and that sort of stuff, lawyers start poring over the paperwork, and they still see online, this is undecided. Yeah. The council have not deemed prior approval.
I suppose what you'd have to do in that circumstance potentially is get hold of a barrister maybe to write, some sort of letter or opinion and give it to the solicitor and explain what has happened.
That's what we did. That's what we did in this case.
Yeah.
And we sent
did they accept it? Or
they did. Yes, they came back a few times.
The bank went for it. Yeah.
Well, the bank weren't involved in us. We had to sort out the problem, and then the bank were been basically waiting for the prior approval status to. So the council's officer came back to me a few times, querying a few things afterwards. Some of the points she'd raised were points that were relevant to a case that we won in the High Court against another council last year. Yeah. So I said, well, here's the consent order from the High Court. You can't do this. You can't take this view because of X, Y, and Z. Yeah. Apart from which it says A, B, and C in the council's in the barrister's opinion in any event. So they went through their process. I think there was perhaps other considerations, and we think perhaps there were other considerations at stake, but.
Yeah, they didn't want it to happen for whatever reason. They've always got some sort of wheels within wheels operating.
Exactly. And there's usually something to do with money at the end of it as well. So,
but they weren't going to get any, were they?
Yeah, exactly. So we had to look at that. But, so obviously there are a few key issues here, and we've touched on a few of those in terms of the resistance to put PD in prior approval, and investor confidence and having to carry out sensitivity analysis and the costs and time in obtaining permission. Yeah. And also how PD and prior approval is particularly useful in terms of taking advantages of, or certainly mitigating the risk in terms of confidence, risk, timing in planning permission, and also having to look at different exits as well to manage investor confidence. You may be in a situation where you may have to hold on to an investment and obtain the rents until you get full vacant possession. Yeah, that can be very difficult as well, because you may be dealing with tenants who are not willing to come out even after you've obtained PD.
There's been a few offices around here and some retail which have gone on the market, and instead of it just being one tenant, there's something like 4. Yeah. And if they're in the 1954 Act and you can't get them out, and they've got a sort of right to continue, at the new market rent afterwards, you can have a real load of bother getting them out. Yeah. And you need to probably pay them money to go. Yeah. So that is a problem. Yeah. 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 And I think vacant offices are worth quite a bit more than ones where, especially, there's a couple of bitty tenants in the building. Yeah. They're not very big, but they're just staying, and
I agree, but I think that's a fine line, because on the one hand, it's also a good thing. Ideally, if you have a tenant who's agreed to come out in 6 to 9 months' time,
and it's going to pay rent. And
so you're paying rent in the meantime. You're getting the best of both worlds.
That's good. Yeah, because you've got your rent and your rates especially covered. But they're coming out.
You can work the PD. You've got time to put in a planning scheme on top of that. Yeah. There are all sorts of angles that you can play. You don't have that freedom, so necessarily, if it's a full vacant possession.
No. So trees, sunlight and daylight, viability and marketing. Tell us about those, David.
So just hopping over a few key risk management areas, things that some of your listeners might just want to keep an eye out for in these sorts of things. I put at the top of that list traffic and parking. Yeah. Now, we often talk about power teams at Progressive, and obviously in some of the courses and in what you and your listeners do as well. And obviously, I would say this, obviously being a planning consultant is a key part of your planning and power team, having a planning consultant. Yeah. But I'd also say a key power team member, particularly on changes of use, has got to be a good parking and highways consultant. Now, that will usually be somebody who works very closely with your own planning consultant. We have a very few very close relationships. And these people are worth getting to know and bringing in early, particularly if you're doing your due diligence, you're trying to work out what you can get in terms of planning on a site when perhaps you're trying to put a bid together.
Yeah.
Because if they can get the ratios down in terms of the amount of car parking spaces needed for a certain number of flats,
Makes a big difference.
it makes a big difference. It can win you another 2 or 3 flats that can be worth another few $100,000, maybe up to $1 million or so on your GDV.
Yeah.
And every penny counts, as you know, in these sorts of situations. Yeah. So that can help with your development.
These are the bits that make all the money, because often when you get an extra 3 flats, okay, they're not free, but let's say a flat costs, I don't know, 50, 60 grand to create, or if you're converting, you've then added a disproportionate amount of profit to your scheme. So these bits are where your profit is.
Absolutely.
Yeah. So I don't use one actually. I just don't think I've had to, other than it's usually down to parking. I always use a parking survey. So I go out, I do it myself. And I have to do it on a Tuesday, Wednesday, and Thursday after 7 p.m. to make
There's
sure
a certain methodology for
there
it.
is. You get the sheet from the council, and then I go and count the spaces and I measure them all. But of course, if I'm doing it, I'm going to find every single on-street parking space, including when people.
You can't do it in school holidays, can you?
No, you're not allowed.
No, it's got to be a week outside, at least a week outside of school holidays as well, I think, to allow for traffic to normalise. Yeah. It's called the Lambeth methodology, isn't it?
Well,
you're effectively doing the Lambeth walk. You do realise you're walking.
I must have got consent on 4 schemes by doing that, and other developers just go to a planning consultant and they go, oh, if you're not at parking, you won't get it.
On-street stress or parking beat surveys, they're called.
So I love doing them. You always find a lot more spaces as well. Who knows whether it's within the rules? It's all a bit grey, but I find one thing that really helps if you spend sort of 3 or 4 hours there, if somebody happens to move whilst you're there, you can sort of track back round and get that space again. And then as somebody else comes into a space that you've already counted, well, that was counted earlier on. You see what I mean? Because they don't specify.
That's chutzpah, right?
There's a bit of chutzpah in there, you can get a lot of space.
Yeah, good. Very good. So, I mean, certainly worth.
And of course, you wouldn't encourage anybody to drive off.
No.
Or not to park there.
Exactly. Right. If it just happens to happen.
If it happens to happen.
Yes. So you've got that. So that's certainly worth it. And particularly as with a lot of these offers that come on the market, or perhaps before they're briefly on the market, they will be a situation where the vendor knows full well that there are PD or prior approval rights. They will often try and put in an application themselves to prove that. But what you often see is they don't know how to work the space very well. They'll end up with oversized one bed or
always
two
too big.
Units.
They use a rubbish architect.
And they're playing it safe because they've got 10 parking spaces and they don't want to go for 12 units. So they're going for 1 space per unit. And you end up with 10 very large units. Probably are too large for the local market. They're not going to sell. So that is how you end up getting those units. They've got the prior approval and you rework the plans. You get a lot more flats out of it and you put a planning application in on top, out the back, and maybe something with the car parking spaces. And then you can suddenly make it work. Because I find 90% of the time, the price they want for the scheme that they've got is completely unrealistic and it doesn't work. Yes, absolutely. There is a caveat to that, and that is not to assume that there is a market for in all places for micro units. And we have mutual friends who have become very overexposed to the vagaries of the current market. Who have a foothold and control of very large deals. We're talking about over 100 in some cases, but all micro units. There's no spread of different size of units, and they're often in relatively virgin markets geographically or regionally, where they're a lot more exposed to what may happen with the market and GDV, so on and so forth. So I don't, it's not. This is not. This point is not necessarily it's about them, but it's about the risks.
It is
on making sure that if you are going to say, well, we think we can get more units out.
You've got to test it.
You've got to test it.
Yeah.
You've got to speak to agents.
Yeah.
You've got to look at deals done, and not just agent sentiment.
No, not listen to the. You've got to. I mean, for me here, I thought so many times about taking an office building and putting all 30 metre squared flats in it.
Yes.
I couldn't find any comparables around it. No one, everyone I've seen has done them at sort of.
And that will be a problem when you go to get finance because the banks valuer will want comparables.
So everything I found was sort of 40 metres plus, something like that.
Yeah.
But obviously I've seen people doing this. A lot of them are sort of more, London centric, and in sort of, let's just say, higher value areas, and it's been working for them. But I could never bridge that gap between Peterborough and those areas. And at one point, I thought about buying a small, just a very small office and doing 2 flats and testing it to see, see what would happen. And then someone did go and do one in a city like Peterborough, and I watched it, and apparently
couldn't sell.
They really have not sold. So I think you've got to be really careful with that in lower value provinces. You've got to test the bloody thing, otherwise you're at 40 metres plus. I think.
So the attitude to keeping parking spaces with units is different. We find within London that a lot of units will sell and retain their value without the need for car parking spaces, and you can sell the car parking spaces separately, often at a premium.
They're sort of 10 grand.
So roughly the same.
7.5 to 15. Maybe.
In central London, towards central London, you're looking at maybe about 15 to 20 grand. One Knightsbridge. One Knightsbridge. I think it's near the Candy. I think it's probably the Candy scheme. There's been, I think they sold off a lot of their underground car parking spaces in developments around there. And I think many years ago, when I was at GVA Grimley, we were involved in advising on such a development, and it added another £1 million to the GDV. But there were different times.
Extreme.
It's a different market. But I think here, particularly outside London, there's a different attitude towards the way in which units are valued with regards to whether or not they have car parking spaces. It tends to be assumed that car parking spaces need to go with the units. I don't know whether or not you found that. So if you don't have, if you have a car parking space, you don't necessarily always get to charge extra for that to the tenants. But
maybe not. I think it's dependent on the area. I think in Peterborough, if it's right in the middle of the city centre, which is actually about usually within 5 minutes, 7 minutes walk of the mainline train station that goes into London, you can get probably 7.5, 10, 15 grand in sort of more extreme.
That would make sense,
You can get that much more for the unit. And there are quite a few developments where there's only been sort of one in particular I can think of. I think the 35-40 flats and only 10 spaces. So it does work here. I think as soon as you're out of the city centre, I've done developments, car parking just comes with a flat and probably worth nothing.
So that's car parking. Flood risk, still worth looking at changes of use in areas which are flood risk. We've managed to successfully get PD on flood zones 2 and 3. When you do so, when you're looking for that, you will need a topo. You'll need a topographical survey. And I think it's really important to instruct an environment consultant very early, ideally one who already has access to the Environment Agency mapping data. Trees, also very important, particularly if you're looking at doing development within the area of existing buildings and there are trees in the boundaries. You want to know what your developable area is. So you'll need to bring on a tree consultant quite early on, look at the root protection areas, and they will define the limits of foundations. not so important when it comes to sort of things like bike sheds and bin stores and that sort of stuff, because they have relatively low foundations, but you want to minimise as much as you can the extent to which you're intruding into root protection areas. There is, in practice, a general rule that there's a bit more give and take in the first 20% to which you intrude into that root protection area, so that if you're only going in no more than 20% into the root protection area, there tends to be a little less harm assumed, a bit more at an acceptable level to the tree. But you need to speak to a qualified tree consultant about that. And then there are issues with regards to heritage. If you're in conservation areas, if you're in settings of listed buildings, obviously you need to be careful about that. And need to be bringing a heritage consultant very, very early. And viability and marketing, we've already talked about this and touched upon it earlier when we talk about doing a deal with somebody, having that evidence about the viability very, very early on, getting the cooperation of the public and the landowner very early. And I mean, those are the key points. Just to summarise: traffic and parking, flood risk, heritage, trees, sunlight and daylight, viability and marketing, and then lastly, I would say community engagement, which is a whole area on its own as well.
There's a specialist around here that does that.
Yes.
And he'll set up sort of public consultation areas for bigger schemes, often big new build sites.
Yes.
That's what you have to do.
Yeah, so you have to consider whether or not you want to engage with neighbours very early. It sometimes
depends on the scheme.
It depends on the scheme. I think for larger schemes, I think you need to, because at some point,
and the officers, if the officers sort of say, you know what, it's city centre, we're going to probably do this under delegated powers. No committee. Most of the time, it's not of benefit. I mean, I had one where they said that was how it was going to be done, but they said, "Oh, do you mind if we put it in the local paper and you know do a bit of a thing with the leader?" So they put it in the local paper, and the leader sort of spoke about how they were helping regenerate part of the city, which was great. But of course, all it did was alert the nightclub owner opposite that we're about to do this. So he just put a complaint straight in saying that his nightclub was going to be shut down. Yeah. In the end, we overcame it, but it slowed everything down and caused issues. So there's a balance here, isn't there?
It is. And I think a lot of people object partly because
people have seen it.
A lot of people object because I think some of it is ego.
Yeah.
They feel as if they're being bypassed by the faceless developer. You'll often hear this phrase, the faceless developer, which is ironic because we had a situation recently where my client, the developer, offered to meet the objecting owners on the other side of the road on site and be available at certain times.
I would do that if they'd registered an objection. I went to the nightclub.
That's exactly what happened.
And I knocked on his door the whole lot, offered to change his windows.
Yes.
At that stage, I think you want to engage
so you're not faceless.
Yeah.
My client wasn't faceless. And still an objection came in afterwards because the guy couldn't make himself available in the evenings or whatever it was.
Yeah.
My client was still regarded as a faceless developer. So some people, you just never be able to please.
No, and they're NIMBYs, a lot of these people.
But also, we've had meetings where a lot of these objections have been knocked on the head because we've spent maybe a good half an hour to an hour just walking them through the plans. People are not used to doing what we do all day long. They're not used to reconciling and interpreting floor plans, elevations, sections, making sense of what's happening. You present an area of green on a roof. It's a green roof only for maintenance. They think, oh, well, hold a second, you're going to be playing ball games out there and that sort of stuff. They don't understand what they're looking at.
We put a massive green roof.
Yes.
And so many people have said that to me. Oh, there's going to be this is going to be for recreation and parties. And like, the engineer's never going to let anyone out there. And it's dangerous. And it's sedum to absorb the rainwater and then control the discharge.
Absolutely. And the difficulty is that if you let objectors run away on a frolic of their own,
a frolic. That's what they do
with their
all
own
these
thoughts.
ideas.
Absolutely. And they get carried away. They start writing to ward councillors.
Yeah, that's true.
Ward councillors
You've got to get them involved.
Start calling the applications.
The officers.
Because often the the rules of what goes to committee and what does not go to committee is determined by the council in a legal document called a constitution, which is a wrapper to a whole bed of rules. And within that wrapper, there's something called the scheme of delegation. And that scheme sets out up the thresholds which will determine when an application has to go to committee and when it doesn't.
Yeah.
Now, I don't expect your listeners to make themselves familiar with a scheme of delegation, but it often makes interesting reading, because we're in a situation where we had a matter that was delegated, and then there was a problem with the consultation period that had to be reconsulted, which meant that people who had not objected in the first place, and it could have gone to delegated powers because it was within the thresholds, there were below a certain number of objections, and those numbers will, by the way, they will differ wherever you are in the council, which council. Some councils will have a threshold of 2 or 5 or 10. So, or you'll have situations where if there are no objections from residents or X number, but whatever it is, if there's an objection from a local residents association, it automatically has to go to committee. So those sorts of things, Now that will differ depending upon what the scheme says.
In the constitution.
But in the scheme, sometimes, so we had delegated and then it was reconsulted, so it dragged out the period of time, which meant that then there were more objections that came in at the last minute, which then took it over the threshold. It was due to go to committee. And
what was the threshold, roughly?
The threshold was at 3 or more, it goes to committee. So it was very, very low threshold. But
what's average?
Usually about 5. Yeah, so...
Do you know what?
A petition only counts as 1, by the way. So if you get a petition with 100 people signing, then you say to the council, so that was only one objection. If you get somebody writing in from a house and they write in again, still only 1 objection. If the person writes in and his wife writes in,
2.
Still 1 objection.
Oh, is it?
It's 1 household. So you've got to do it by households.
Okay.
But also, the scheme will often refer to material objections. So if you've got prior approval, and then you put in an application to say, well, okay, we want to amend the roof line, so on and so forth. And the objections come in against the... you get 1 objection, say, against the appearance of the roof line, and another objection against the fact that you're having... all these extra number of units and all these parking spaces.
Crime.
It's
antisocial behaviour.
Yeah, absolutely. And the faceless developer, of course. Don't forget the faceless developer. Then the first objection is material because it related to the roof. But the second objection, because it related to the number of units and the number of parking spaces, which was a prior approval matter, is not material. And so you can convince the officer that they have to disregard that in terms of counting the number of objections.
That's interesting. That's very interesting.
So sometimes knowing the detail of this stuff is particularly important.
Yeah, because a lot of the time the objections come in and they're about a load of nonsense which is not relevant. Like, don't think it'll be good for the area. Full stop. Is that an objection?
No, it's not. Well, you have to put
it in
specifics. It's not a valid objection.
So therefore it doesn't count.
So it's about in the same category as saying it harms house prices.
Yeah. So is that a valid? Does that count in terms of the 5? Well,
they'd have to say not really, because they'd have to specify why it's not good for the area.
Yeah, but a lot of them won't. They'll just
not good for the area because it doesn't. It's not good for the street scene. It's disruptive. Yes, because you put it in the material terms. But you can't paint windows into men's souls. You can't try and interpret what they're thinking. They need people need to be specific, and if they're vague, then you have the opportunity to go back to the officer, depending upon how robust officers are, and say it's not really quite on point. But I think often if you are in a situation where you have objections against the scheme, I think it often works very well, depending upon the neighbour, depending upon the resident, the person you're speaking to. If you are then seen to cooperate with them, revise a scheme to meet their concerns
through the officer, because you can just end up in these protracted, nonsensical sort of circles with these individuals and get nowhere. So you sort of I've taken your your comments on board. We're revising the scheme, and then deal with the officer.
But you've got to also think about how long it takes for things to get written up by the officer or go to committee. The officer may be away on holiday. There may be delays. Sometimes you want to be dealing directly with the owner. You don't want to lose control of that. Certainly, at all times, keep the officers in the loop about it. And also, if there has been a ward councillor who's involved, keep them copied in as well. We've had situations where we've managed to get the ward councillor to withdraw an objection or to withdraw a call-in.
Have you?
Now, often, that information doesn't get back to the objector. Call it in, and because there's a time lag often between revised proposals being submitted to the council and being posted online, you often find that the objection that you're speaking to the neighbour about that they submitted is now out of date because they've not taken into account the fact that there's revised proposals that you've now submitted, and so you now need to get them
go out for reconsultation.
They need to go
but then they haven't. They have to re-object. Do they have to re-object?
They would have to re-object,
and they don't because they don't realise the process.
But if they still have an objection on the record, even though it's against the now superseded scheme, then you still have to get them to formally withdraw that objection.
Oh, you do? Right,
yes. Otherwise, there's all sorts of issues, and we can go on forever about these sorts of things. But
so when a ward councillor calls it in, does that mean it's going to committee?
Usually, yes, because
I've never had that done to me. Usually what we do, we go to the ward councillors beforehand, so this is what we're doing, what do you think?
Okay.
And 90% of the time they go fine.
Yes.
Sometimes they come out and have a look, I talk them around it, and they're like, okay, is it going to be like this? Is it going to be like that? The units aren't going to be too small. You're not going to have any bedrooms without any windows. And I know the officers won't let us, whatever. And then they're usually happy, and then they go.
Well, on larger schemes, that would make sense, and I would understand if you do that. But and a lot of your listeners would not normally do this on smaller schemes, particularly if you've already got prior approval for going up into the roof, for instance. And all your application is concerned about is changing the pitch, putting some roof lights and some dormers in to try and make those units work. So in those cases, you think, well, it's pretty bog standard, and and see, the thing is, other people try and play the game with it because they know that you need those roof alterations in order to make the scheme work. And so they'll try and stir up all sorts of nonsense with it in any event. So it's about trying to control the prospect of people forcing design changes on you. Stop them from stirring up ward councillors, or placing pressure on a committee to refuse a scheme against officers' recommendations. So it helps us take the sting out of objections. But as you say, you have to be fairly cute about how you're going to do it, when you're going to do it, and so on and so forth. And there are all sorts of ways in which you can do it: writing letters, local exhibitions, roundtable informal presentations. You have to probably speak to your planning consultant or your PR consultant about what seems the best thing to do for that particular case. But I think, if I may, just generally round up on my 5 top tips in meetings with residents and neighbours.
Far away, David.
So the first thing I do, let's imagine you're in a situation where you're presenting to neighbours. You've hired out some space in the local community hall. You've got your boards up. It's all presenting the benefits and what it's going to do for the community. And you've got people coming along to the presentation during the day or in an evening, and you're going to talk them through the scheme. Some of these people are neutral. Some of them are for it. But there might be one or two who's going to kick off. And there's always usually, you may have maybe, let's say, 50 people. There's usually only 1 or 2 who were the main ringleaders and trying to stir everybody
everyone else on board.
So it's all about trying to figure out who those people are.
And then neutralise them.
Yes. So
in the eyes of the others.
So find out where they live and what their concerns are. It's an opportunity for them to sound off. Can be a bit of a cathartic exercise for them. Let some steam off.
Do you know what? You're right.
Yes. Or I wouldn't necessarily. I would never say that they're right. I would say that's a very good point. I think it's an excellent point, and compliment them about it. I know Rob's favourite is thanks for the feedback, but that sounds a little bit patronising.
I don't think that works. That's the sort of thing I'll say to my wife when she's annoying me. Thanks for the update.
Yes, thank you.
Yes, thank you.
Good luck with that one, yeah. But they feel they've been listened to in a way. You're kind of inviting that. You then need to describe the scheme briefly to them, even if they think that they know what the scheme is about. Ask their permission. Yeah. Would you mind if I just simply walk you through very quickly what the scheme is, what we're proposing to do, and when we can talk about how that particularly relates to you and where you are. Yeah. Okay? So much of the time, people object to what they don't understand, often out of fear of change. So if you are helping to make them understand, because they may be thinking, don't like that area where they're going to have ball games on 2 or 3 stories up, but hold a second, that's a green roof. Yeah. Okay. So
no one's allowed out there.
So no one's allowed.
These are the reasons why.
Maintenance purposes only, and for something we'll come on to in a moment as well. You will be extra protected through that because there will be planning conditions that will prevent us from doing so. And if we breach those planning conditions, we're in trouble with the council and we'll have to stop.
Deep schlop.
Absolutely, absolutely. So the next point is really important. These people can get very heated with you. They'll start jabbing and finger pointing in some cases as well. Yeah. Particularly if you say thanks for the feedback. But don't get drawn into an argument. It's really important to keep your cool, keep your calm about that. Keep on saying, that's a very good point. Thanks for noting that. Have a few stock phrases in your mind ready for those particular situations. Let them speak. Then take a pause, because pauses and silences in these can help to let the temperature come down a little bit as well. And I can understand it can be very annoying and objectors can get under your skin about it, but it's not personal. Don't take it personally. There's usually something behind it in terms of their fear or their concerns. So take a note of what they're saying as well, because there will need to be feedback forms. Get them to encourage them to sign feedback forms so that you can then round up afterwards with the team and go through these points as well. And distill their concerns down to particular points. So there will often be a tirade of complaints about it. Yeah. So a good tactic is often to say, okay, can I help you to try and distill these concerns so that I can understand them in the language that we have to work? So you're then trying to focus them away from an emotive state of being towards a more rational state of being. An
objective sort of
place. It's a halfway meeting point towards your objective. You're not necessarily going to drag them all the way to your point, but you're changing the temperature of the conversation, the tone of the conversation. So work with that if you can. You'll expect the usual faceless developer BS, even after the meeting. You've just been standing in front of
making all the money.
You're just taking their abuse for the last half hour, and you're still a faceless developer. So you can't please everybody.
But the other people in the room who are probably the most important ones, because that they've got the bulk of the not votes but potential objections. Will probably have decided you're no longer a faceless developer, even if the finger pointer is saying you are.
Yes.
And if you've dealt with the finger pointer quite well, put up with quite a lot, and brought some good points out, they're probably going to be a lot more convinced, even if the finger pointer isn't.
And don't let the finger pointer monopolise your time for those reasons, Mark, as well. So also highlight the benefits and the needs of the area as well. Also very important, because with a lot of this, it can be often very, very leading towards a sort of a more negative tone. So you're trying to balance the mood of the conversation, always trying to bring it back to the benefits and the needs of the area, and indicate to them some control and some direction. So there's a few tips within this. It kind of gives them a level of comfort. It gives them a level of assurance as well. Yeah. They don't understand the planning process. You're trying to understand that their interests are going to be looked after here. So telling them that there are going to be planning conditions to deal with materials or design or prevent the use of green roofs and that sort of stuff as well. Try to rephrase their concern as a matter for planning conditions. So you can deal with that. Always try and give them something to keep them busy afterwards as well. Because if they are busy doing something else, they're not going to necessarily be time to write more objections. So one thing you can do is to say, well, if you're concerned about the materials, write to the officer and say, we'd like to see the following materials, because those materials we're going to have to agree on planning conditions afterwards. The officers can then take that into account. So you're kicking the can down the road with it, so it doesn't get in the way of as an objection, this one. Another one is, particularly if you're outside London, you have what's called non-unitary authorities. You have the Borough Council, District Council, who decides the application. Highways matters tend to be dealt with at county level. So what often happens is there's a little bit of a political tension often between the county and the borough and the district. And the members don't like to be, the members at the borough district level don't like to be the
parish council.
No, the parish council slightly said you get parish council, then borough district council, then county council. So highways matters, traffic flows, parking, those are big issues often and the hot potatoes for residents. But it's a county matter. So the county has to be consulted and they will deal with your transport consultant. But you'll often get the people on the ground who don't agree with that because they say they have a different experience and they know better because they live there. But often, if it's sorted out at a technical level, you can get them to say, well, OK, if you still don't agree with the county, speak to your borough or district member who will give you your county representative and then speak to them. It probably won't change the way in which the county work, but these people will be busy with their own lives, with shopping, with family, with work. Then they've got to try and find the time to speak to their borough member, to find out the county member, and then to write to them as well. So you're appearing to be helpful whilst giving them stuff to do in the meantime and keeping them away from being a keyboard warrior against your scheme. But also, it makes it politically more palatable for the body that actually decides your application, such as the councillors at borough district level. Because if they have to approve a scheme, but they can say, well, you know what, we don't like the highways matters, but that was really a county matter, they can kind of blame their county colleagues about it. It's kind of pushing the responsibility onto somebody else's shoulders. So you're making it somebody else's issue. So that's a good one for that.
David, I think everybody has got more than a few morsels out of that sort of deep dive into planning. I love the shimmies, I love the chutzpah, and I think we've had some fun. How can people get in contact with you if they want to use your services? Because obviously you're helping with people. You're helping people with planning matters on a daily basis.
Well, my email address is the main one. It's david@drkplanning.co.uk. david@drkplanning.co.uk. You can also find me on Facebook and through LinkedIn as well. So all that remains is for me to say thank you very much, Mark.
And thank you, David. That has been Mark Homer and David Kemp for Mark My Words.